Senate today debated the autonomy for local governments in Nigeria, asking states and LGs to fully comply with Supreme Court judgment. And the governor of Bayelsa State, Oduoye Diri, says Nigeria can progress if we can dialogue to tackle our problems and fix the holes in our federalism. Hello everyone, welcome to the program. This is Politics Today, live on Channels Television. I'm Sean Okibaloye. Tonight, our conversations around the structure of Nigeria, the state of the nation, and the way forward. And so, stick around because these conversations are important for us to get it right. Well, we might be in economic quagmire, but for us to find our path in the dark, we need to also know where the future is, where it lies, and exactly how to get there. So tonight, let's get together, everyone, and let's chart a way forward. Let me first and foremost tell you what the Bayelsa State Governor has said. But first and foremost, let's check out some of your political roundup stories.
The Nigerian Senate has asked state and local governments to immediately comply with the Supreme Court judgment, particularly relating to local government accounts and funds given directly to them. The Senate also resolved to take immediate steps to alter sections of the Constitution to give full autonomy to local government administration in the country. The resolution was announced by the Deputy Senate President, Senator Jibril Baro, lawmakers upon reconvening from a closed-door session where the chamber debated attempts by some state governments to circumvent the ruling of the Supreme Court on July 11. The House of Representatives have mandated its Constitutional Review Committee to organize public hearings with a view to addressing permanently the delay in justice delivery in the country and restoring the confidence in the judiciary. This is sequel to a motion raised by Honorable Ganiu Ayuba, drawing attention to cases in trial courts that should have been resolved within months but have lasted 4 to 5 years before judgment is delivered. In the meantime, the House has mandated its Committee on Works to ascertain the causes of incessant building collapse and provide a lasting solution to curb the menace. Some residents of Edo State, who are members of the People's Democratic Party (PDP) in Abuja, have staged a peaceful protest to the headquarters of the Independent National Electoral Commission (INEC), asking the Edo State PDP governorship candidate be given unfettered access to all information relating to the September 21st governorship elections. The protesters alleged that the INEC in Edo is denying the PDP candidate Mr. Sway Gadalo access to the INEC result viewing portal and the bimodal voter system BVAS, which was deployed for the election. The Edo State Resident Electoral Commissioner Anubom Onoha has denied allegations against him by the People's Democratic Party (PDP) that he resisted requests to gain access to the bimodal voter accreditation system BVAS inspection before the just concluded gubernatorial elections in the state. In a statement issued by Mr. Onoha, he described the PDP's allegation as baseless, misleading, and devoid of the truth. Mr. Onoha notes that he never denied any political party, agents, or representatives access to the BVAS ahead of the contestation in courts to inspect the BVAS. The All Progressives Congress, APC in Edo State, says the Independent National Electoral Commission, INEC, has agreed to move the inspection of electoral material to Thursday, October 10, to allow the party prepare itself. The chairman of the APC in Edo State, Jarrett Tenebe, and the legal counsel, Victor Ohiosunwan, confirmed to journalists that they did not come with all the necessary materials because of a mix-up in the inspection process. The legal team of the People's Democratic Party (PDP), who were also at the Edo INEC state headquarters in Benin City, however, did not grant any interviews. The Association of Local Governments of Nigeria (ALGAN) has promised to prioritize key areas of development across local government councils in the country. Addressing journalists in Abuja, the newly elected chairman of the association, Mr. Bello Lawal, notes that the local government administration will continue to focus on grassroots development to empower local communities through sustainable projects and initiatives to promote economic growth, infrastructure development, and social welfare at the local level. He promised to work to ensure that the 774 local government chairmen work towards improving basic education and strengthening primary health care as well as security in their various local councils. He also condemned the attack on local government councils in Rivers State.
There are those who are truly worried about the state and the structure of the nation, and we think that we cannot get it right if we don't fix the structure. One of them is the Bayelsa State Governor, Doye Diri, who is a former lawmaker and is serving as a second-term governor. Senator Doye Diri says Nigeria is at a crossroads and must go back to a true federalism if it must survive and realize its economic potential. Senator Doye says a situation where only the federal government can create local government is an aberration. He said this today while delivering the 64th University of Nigeria Founders Day lecture titled Rethinking Our Future, the Need for True Federalism and Economic Renaissance. It was at the Nsukka campus of the university. Governor Diri says it is through dialogue and collaboration that we will pave the way for a brighter future for all Nigerians. Take a listen to him.
State commissioner goes to Abuja to go and receive FAC allocation. So my question is that healthy for this country to develop? Well, the FAC allocations may solve some immediate problems. They may fill our coffers. They may also drain our creativity, leaving us with a deficit of innovation of ideas and impede our forward momentum. Now, this other issue of fiscal federalism. A missing component in our current structure offers federating units the authority to flex their economic muscles, thus able to express their cultural and political identities within a national framework. These would ease the tensions that arise from the feeling of marginalization, as each state would have the autonomy to address its own challenges without undue interference from the center. Therefore, federalism in its ideal form is the key that unlocks the door to a prosperous, competitive, and self-sustaining Nigeria.
That's Governor Diri there talking about the state of federalism. This is quite important because our set of conversation tonight is hinged on the structure of the nation. It's interesting that he gave that lecture today, which is going to serve as some premise to what we're discussing. But let me also tell you what happened today in Ondo State, where Governor Lucky Ayedatiwa has wielded a big stick on one of his political aides. The governor today sacked one of his political aides, the Special Assistant on Forestry in Central District, Mr. Adeboye Taufik Ewenla, with immediate effect. According to a press statement issued by the governor's chief press secretary, Ebenezer Adeniyo, it reveals that reason for the governor's action follows allegation of bribery and intimidation leveled against Mr. Ewenla by some timber merchants in the state. The statement further notes that Governor Ayedatiwa also ordered a probe into the activities of those saddled with the responsibility of managing forest reserves in the state. A replacement, according to the Ondo State Governor for Mr. Ewenla, will be announced in due course, but the governor urged all political appointees to conduct themselves in line with the provisions of the law and rules guiding their duties. And of course, today we saw a closed-door session, which lasted for several minutes. Now, the Senate came out of that closed-door section and asked that state and local government to immediately comply with the Supreme Court judgment, particularly relating to local government accounts and the funds given directly to them. The Senate also resolved to take immediate steps to alter sections of the Constitution to give full autonomy to local government administration in the country. The resolutions was announced by the Deputy Senate President, Senator Jibrin Barau. Lawmakers upon the reconvening from a closed-door session where the chamber debated attempts by some state governments to circumvent the ruling of the Supreme Court. I have the man who moved the motion on the floor today, Senator Tony Nwoye. He's live with me here in the studio. But before we get into that, there is another very interesting scenario playing out. Is the fact that the Supreme Court has scheduled on October 22 to hear a suit filed by 16 state governments. Well, it was originally filed by the Kogi state government. Now 15 other states have now asked the Supreme Court to be joined in that matter. And they're challenging the legality of the Economic and Financial Crimes Commission, EFCC, and they are contesting the constitutionality of the laws establishing the EFCC. The 7-man panel of the justices led by Justice Uwane Abahaji on Tuesday fixed October 22 for hearing in that matter, and they were joined by co-plaintiffs and leave granted for consolidation of the case in the suit originally filed by the Kogi State government. Don't forget, Kano, Lagos, Kogi State, or some of these states have established their own anti-corruption agencies. Now, there is a federal anti-corruption agency like the EFCC. There's been some issues in the past, and there are judgments of court to the effect that some cases cannot be heard on corruption matter by the EFCC because there is the establishment of state-controlled or state-established corruption agencies. Now, this is 16 states, and we now hear that more states want to join them to challenge the constitutionality in the establishment of the EFCC. First and foremost, let's deal with this matter before coming to Senator Tony Nwoye. I'm being joined by one of the very most experienced lawyers in Nigeria, an elder statesman in every right, senior advocate of Nigeria, Chief Robert Clarke, who joins us live from Surulere in Lagos. Thank you so much, Chief Clarke, for joining us, and it's good to see you tonight on the program. Hello, Chief Clarke. I don't know if you can hear me.
I'm hearing you very well.
Fabulous. It's good to hear. I mean, I've heard that voice. It's been a while, and it's good to see you, sir. But let's begin the conversation.
Well, you jettisoned me. You jettisoned me.
That's not possible. I don't just want to disturb you. I don't just want to disturb you. You're going to be 19 in a matter of months, isn't it? And, I mean, much respect to your knowledge, wisdom, and your experience.
Thank you very much.
Thank you so much.
It's always a pleasure.
Thank you so much. Always a pleasure having you join us. I want to get your view on this suit that has been brought before the Supreme Court. Of course, the Supreme Court has the court that can hear such a matter where there is a conflict or there is a dispute between state and federal agencies or federal government. Now, what is your view? The challenging the constitutionality of the establishment or the laws establishing the EFCC?
Well, I don't know the reasons why they are doing so. I do not have before me any documents showing the application that has been made. But from what you are trying to tell me, hello?
I'm here, sir. Please go ahead.
From what you are trying to tell, From what you are trying to tell me, I can believe that they are not happy with what is going on. They want the matter to be reviewed constitutionally. And I believe that they have every right to do so. But until I see the papers or the application before the court, it will be difficult for me to make any statement on their reasons, because they are not making oral applications, but they are rather making specific written applications. So to that extent, in my opinion, or not, you permit me that area. What I'm trying to say is the legitimacy or no legitimacy of a law can be challenged by the governors. They have a legal right so to do, and I don't blame them. The facts upon which they are basing their application, I don't know. So I can just tell you that they have a legal right as governors to bring before the Supreme Court an action that challenges a law that is repugnant or is not informed with the Constitution. So that's how far I can say now. But if you enlighten me as to what facts they are bringing before the Supreme Court for their application, then I'll be in a better position to give a line of thought.
Yeah, Chief Clarke, part of the argument is the road involvement of states when making laws to establish these kind of agencies, and perhaps the procedure upon which such laws were made. And we do know that the history of the EFCC dates back to the Obasanjo administration. That was when the EFCC was established. But some of these states are contending that a law that was put in place to establish an institution that was in the first place without the consent of the state is something that they want to challenge in court. And we do know that when states come together, in the case of the VAT, they challenged the federal government, and we knew what came about. But in the process of lawmaking under our constitution and in constitutional law, what do you make of the stance of the state? Now there are 16 now. Kogi State for instituting that suit, and 15 other states joining in.
If you look at the antecedents of this law, the operation of this law, many of the very, very notorious, I will not use the word notorious derogatorily, has been involving governors, sitting governors, governors that are out of office, and therefore they have every right to be jittery. If anybody wants to feel they are being jittery, to be jittery that this matter is merely created for the governor's purpose. But I do not see to that point. The creation of a law is the prerequisite of the legislatures. If there is any specific thing in that law that runs against the Constitution, then they should let us see it, and then definitely the court will set it aside. But if there is no law today that says the federal government cannot pass a law relating to criminal acts of governors during the period of executive work, then I doubt whether they are treading the correct ground. They cannot challenge the federal government for implementing an existing law. They cannot challenge the police or any other agency of governance that is executing the existence of an existing law. This law they are trying to challenge is a law that has been created and is part of our law as of today. So if they want to challenge it, if there are reasonable grounds to say the federal government has no power to be the executors of this law, then one looks at it at a different way. If they feel that even if the law is correct, it should be implemented both by the federal government and the state government. There are, I don't know what angles they are actually challenging.
Let me bring some context, a bit more of details on what the grounds. This was initially a Kogi State Attorney General's move on this matter. And the contention majorly was that they're seeking a declaration that the federal government, through the Nigerian Federal Intelligence Unit, the NFIU, lacked the power to issue any directive, guideline, advisory, or any instrument for the administration and management of funds belonging to the Kogi State government. They also sought the declaration that the EFCC, the NFIU, or any agency of the federal government cannot investigate requisition documents, invite or arrest anyone with respect to offenses arising from or touching on the administration and management of funds belonging to the Kogi State government. Now, these are some of the premises in which they also went to court. They argue that bringing a convention into the Nigerian law, the provision of Section 12 must be complied with. According to them, the Constitution requires that the majority of the state assembly, houses of assembly, have to agree to bring the convention before passing the EFCC Act and others, which was allegedly never done. That was the main premise upon which the Kogi State government went to court.
Okay. I can now say the background why in particular the Kogi State government has gone to court, because they are in the soup as of now. But this is a point of law that is not meant for you and I to look at and be, talking about it on air as if it's a matter before the Supreme Court now. The Supreme Court is to look into it. My advice is that we can give opinions But we ought to be very, very, very careful in giving an opinion when the matter is now before the Supreme Court. This is a sitting matter. The Supreme Court judges have to sit down together and deliberate about it. So we have to be very careful. But there are no facts that one can say is involved in this. But in doing all these things, we have to be careful because most of the facts as of today they are going to use is already, what you and I know of the acts of sitting governors who have had the opportunity to sit on our Commonwealth and the way and manner they have done it. But let me assure you that the Supreme Court has the power, as of now, has the power to look into their complaint. If their complaint has a basis in law, definitely, I am quite sure that the panel of Supreme Court judges we have now are dedicated judges and who will look at it with full dedication required of their professionalism.
Yeah, great. So now let me take you, Chief Clarke, to the matter involving the role and the execution of such roles by the judiciary. And we talk about the independence of the judiciary and the manner in which some judges or some court administer their roles. There are a lot of people who find a problem but the manner in which court of coordinate jurisdiction will deliver judgment in matter before them. People will raise the issue of coordination. People will raise the issue of bias. People will raise the issue of manipulation of the court processes. But as a very senior member of the bar, how do you think our country and our judicial system can overcome and solve this riddle that has sometimes brought the judiciary to disrepute?
It is very unfortunate, very, very, very unfortunate. I have discovered that the question of the interpretation of electoral matters, which takes over almost 100% of what you are referring to, are always on television, being judgments by one court in Sokoto against an act in Shagamu, and all these things. My view now is that if we are not careful in Nigeria today, we will turn our courts into a kangaroo court, regardless of the status. Because if a court of coordinate jurisdiction give judgments at variance with each other, and superior courts give another judgment, and we make all these issues on television, whereby the ordinary man or woman does not even know what the courts are saying. We are treading on very dangerous ground. And we have to be very careful. I was listening to one of your sister stations this morning. A lawyer was asked this type of question. And I was not happy even the way the lawyer was replying it. The lawyer was being asked whether the judgment in the Federal High Court is superior to a judgment the state high court, and why there should be conflict and all. It doesn't all go well for the judiciary in this country. We have to be very careful. And if any lawyer is being asked such a question, he should lay it down in a way and manner where lay persons like you and I can be able to learn from, For instance, if a state high court makes an order on a matter it has no jurisdiction, and the same matter is taken before a federal high court that has jurisdiction, definitely the judgment of the federal high court, who has jurisdiction, will be relied upon more than the state high court that has no jurisdiction. So we have to be careful that we, our lawyers ourselves, we should be able to enlighten viewers that what we are seeing now is not that Nigeria has kangaroo judges, but that the question of jurisdiction is at play. And we lawyers use the question of jurisdiction a lot to take advantage of our cases. So my view about this again is that there is no reason why today we should be bogged down by court judgments. we have created a situation in Nigeria now that if you are not careful, without sitting down, getting our senses correctly, and reenact and do or restructure whatever we want to do, we'll be treading on very, very dangerous grounds.
But Chief Clarke, how do we solve this problem? We have a new CJN in place, but of course we do know that some of these issues are procedural. If you have any problem, if the NJC, for example, has any issue, I'm not sure the NJC can act unilaterally without any petition coming up. Or what do you think is the best ways in handling this? This has actually made a mess and a joke of our court system, where people think that they can jump from one court or the other in fishing and shopping for judgment, and when there are other courts that have given judgment in those kind of cases. I mean, it's terrible, and it mostly happens, like you said, electoral matter and political matters.
Well, let me give you a clear example, because I'm not going to shut up my mouth at my age and see many things happening in the judiciary myself that I'm not happy about. For instance, when the 1999 Constitution was being written by many of our colleagues who were good lawyers then, they never arrogated to the Supreme Court the power on electoral matters, except for the Supreme Court, except for the apex court, except to the presidency. All election matters emanate at the Court of Appeal level. But during the period of one of my very good friends at CG, it was decided by the Supreme Court judges themselves. Because when they were arguing this matter before, I told them that you have created a self-inflicted injury. Because today you are claiming you are the greatest working Supreme Court in Africa. You are the greatest Supreme Court judge or something in the bench at the Court of Appeal. And we will not have had all these problems while the Supreme Court today will be having on its list 500 matters, pre-election matters. Then they created it and they are suffering from it today. And they too should take it out, be able to allow Nigeria to breathe. I don't want to tell you about the instance that brought it up or the history that brought it up, but virtually every Nigerian knows about it. It's very unfortunate. Today, we find the Supreme Court hearing pre-election matters and using the same appeal on the pre-election matter to make, pronouncement on election matter. Look at Zamfara case. Look at what the Supreme Court did to Zamfara case. It was a pre-election matter, and it got to the Supreme Court on a seat of 5 judges, not the Constitutional Court, but they sat there because they are kings of all kings and lords of all lords, as some of them say. And they decided to declare election petition matter on an appeal when they know they had no jurisdiction. Most of these problems is created by them too. And if we are not careful, Nigeria has to sit down and reform, especially on election matters. We have to have a new set of law that will guide us in election matters. If not, we're in trouble.
One matter, because you've seen Nigeria. Nigeria was, with some of you, you saw Nigeria. You are way older than the nation itself. Nigeria is just 64.
I was 12 years older than. I am 12 years older than the nation.
Absolutely.
I'm nearing my 90.
Yeah. So you are a senior brother to the nation, if you can put it that way. So
yes.
You've seen it all.
But I don't bet to. I agree with you.
You've seen it all. You've seen how everything has progressed. Yeah. So.
And at my age now, I should be able to say it all.
Absolutely. Now, give us an understanding. You heard what Governor of Bayelsa says there about our federalism. What has become the Senate today debated the local government autonomy. Some states are still not complying. Some local government are still not in full picture of the judgment of the Supreme Court. Now, how do we fix this imbalance? The senator said there must be an urgent attention in the constitutional amendment to permanently fixing the role of the local government. But then, why is it difficult, Chief Clarke, to how we can make the very grassroots governance in Nigeria function well? How can we permanently fix the structure of this country? What structure or what style fits our nation? You've seen it all. What can you tell? We've seen parliamentary system of government.
Let me
We've seen
draw from my own experience.
Yes, sir.
Let me draw on my experience. Very, very good. The Chinese have surrounded us now with many things. But they have a proverb. The Chinese says, to build, you must destroy. That is the Chinese slogan, that to build, you must destroy. So I am appealing to the president today and to those who are in authority, let us destroy all these laws we have now and come and restructure the whole thing. Because you can't build something on nothing. We have nothing now. This local government judgment of the Supreme Court, I'm not happy the way it got to the Supreme Court. There are many ways, and that's why when the Supreme Court did that without consulting senior members of the bar who could have given them, I don't agree with the Supreme Court on that judgment. Not on the basis of what they have done. If they had wanted to change the whole concept of that law, we will have done so under another way of restructuring.
So how do we destroy and start all over again? Because there are a lot of people who say this restructuring. How do we do that? Do you see the present president being able to take that political move? Because it's going to be a very strong political move. And it's very tricky.
Look, when I was fortunate to be the former president's lawyer, the very gentleman I will always remember, I was his lawyer for 18 months. And when he was out of office, that is Jonathan, there was a time when he was the president, he wanted to restructure the law. But I told him that you cannot make a law when there is no legal tripod upon which you can place it upon. Because the same people who you want to restructure their laws are enjoying and benefiting from this law so much that to find a new member who has never really, had more than one small car, wants to become a member of the House of Assembly, or wants to become, and within 2 or 3 years, you see the same man whom you knew was riding a tattered car. You will know the purposes of the office of that job is very good. And you're asking the man now to come and relinquish that job. They will not. None of these members today, from the president of the Senate to all these legislators, who will want to relinquish the journey their footsteps are on. Therefore, the president must do this. If I am somebody they can listen to, call a constitutional conference. But before you call the constitutional conference, send a bill to the parliament that, look, I want to restructure, but I want you to give me a bill that the way and manner I'm going to do it, this, and this, you will approve it and allow it to go for referendum after your approval. Without that, any restructuring being done outside any legal basis goes to nowhere. And Jonathan found himself in that position. Look how much was spent by him. Today, Debacle, my good brother, will be telling you, bring back this thing. On what basis? Whom are you going to give it to? If you bring it to their house today, they will throw it away. Because how can you say a man who before he became a member of the house was only earning about 10,000 a month, now finds that he's earning 5 million a month, and you say he should come and he won't do it. So let's be honest. The best way, ask Mr. President, send a bill to the House of, to the Parliament that I want to do this. I want to call a conference. I want you to note that at the end of the day, whatever the conference decides upon, I will represent it to you in the House. Give it your approval and let me send it for referendum.
All right.
To give it the validity of law that is needed. Once we do that, we won't have all this problem.
All right.
We are human beings. We have made laws which we didn't know the effect. Now that we are seeing the effects and we are seeing the manipulation by politicians themselves after what they are enjoying as practice of the office. So my advice is that we can still restructure.
All right.
But we must do it so that it will have a legal basis.
Chief
we
Robert
must have
Clarke.
a legal basis.
Yeah. I'm very sure that
Yes,
your experience and your legal advice tonight will get to the right quarters, and I hope that they use them. But thank you so much. It's always good to learn from your wealth of wisdom and experience. Thank you so much indeed, Chief Robert Clarke, Senior Advocate of Nigeria, by far one of the most experienced lawyers you can find around. Thank you so much indeed.
God bless you for me always.
Thank you so much, Clarke. It's always a pleasure, sir. Well, let's turn our attention to Senator Tony Nwoye, the man who moved on the floor of the Senate and sent the Senate into a closed-door session. Senator Tony Nwoye, it's good to see you. Thank you so much for your time.
Thank you, my brother Sheung.
What came up? What came in your mind? Because one would think that the Supreme Court judgment suffices, and states do not need any advisory to be able to implement, and the local government will need naturally just fall in line. But you were very moved and emotional about the state of affairs. What exactly came to your mind?
What came to my mind was that I remember the pre-1999 era when the local government system was very functional, when there were meaningful developments at the local government, when the poverty level was at the lowest ebb, when some local government chairmen, even up to 2003, when some council chairmen were able to do small roads, small drainage, small rural roads and co. And I know that those things have vanished. The local government system is going to extinction, has been shook up. They are not existing. Some governors are guilty, some are not guilty of at charge as concerns this thing. So when the president of this country, President Ahmed Bola Tinubu, who belongs to another party, different from where I belong, when through his Attorney General, they came and instituted this action, we were like, let us watch and know whether this will solve this problem. And on July 11th, 2024, Supreme Court's full panel, seven panel, full panel, Justice Abiru, Justice Sameya, Justice Chioma Nwosu, Justice Garba Lawal, Justice Moore Adumen, Justice Emmanuel Agim, and maybe one other justice.
Led by Justice Agim, yeah.
Led by Justice Agim, they delivered a landmark judgment. And the judgment went all the way to say, don't tamper with this money again. This judgment envisaged the so-called Section 162, subsection 6. Some of the state governments are relying upon to create what they call JAC, just like my own state. I don't want to personalize to Anambra State. Joint local government consolidated account, joint local government account, joint security trust account. These Supreme Court justices saw tomorrow in their judgment, and they gave express order, Sheun. Change from page 28, page 29, page 30, 31, 32, 33, 34 of the Supreme Court judgment. The late judgment by Justice Agim, even page 54 and page 55, where they say no state assembly should pass any law to interfere with this sharing.
In fact, in that part of the ratio of that judgment says, and the court did rule, that Section 162, subsection 3 of the Constitution, that there is no assumption of the law that the law did not intend a joint ownership of the amount standing to the credit of the federation account to each of the 3 tiers of government.
Yes.
Although some state government and some governors will tell you that there isn't anything as 3 tiers of government, it's only 2 tiers. the federal and the state.
But
the state should have the independence to be able to control what belongs to the state, which are local government. And in fact, the federal government should not be have the premise to be able to, appropriate how many local government in each state. But it does look at that Supreme Court judgment and said, no, 3 tiers.
3 tiers. They saying the Supreme Court justices saw tomorrow. They know that what they have been doing is that we are going to continue with it. And they say there are 3 tiers. And that Constitution never envisaged joint ownership.
But there is a problem here, Senator, don't you think? That our federalism envisage a 2-tier. The federal and the constituent unit. The state government and the federal. That is what a federal, and compared to other federal...
Is that the reason why a state governor who receives money in the name of state allocation from federation account, who receives money from the ecological fund monthly in the name of disaster, who receives money once in a while from the President Ahmed Bola Tinubu in the name of infrastructure fund, which you don't know which infrastructure is meant for, who received 13% derivation. Now the money meant for the local people, local government, that state government will keep on using a shock to still siphon this money.
So you over the years, what you have discovered is that the state are taking away the money and not allow the local government to function.
Go to local governments. They are dead places. She will go to different local governments. They are dead places.
And they are the closest to the Nigerian
people. The grassroots. That is why there's high level of insecurity. Some governors are not taking the money, while some are taking. That is why there's high level of unemployment. That is why the high level of youth restivity. That is why restiveness. That is why high level of insecurity. Because this local government system is the closest to the grassroots, to the people.
But the federal government has said going forward, and they gave a deadline, that on such a deadline, no monies will go to the local government except if they've done the...
That was the essence of my motion. For instance, yesterday, the State House of Assembly, Anambra, passed executive bill sent by my governor, creating 3 different accounts in violation, in flagrant violation. Yes. My motion did not mention any state, but I just give an instance. So, if you don't speak out, what they want us to do is to say, go to court. Go to which court? Supreme Court envisage. Check page 33 of that judgment.
Yes, we'll check it. Just give me a moment, Senator. We'll go on a break. But when we come back, there's so much different dimension to all of it. But Senator Tony Nwoye is here with us. There was a powerful motion on the floor today, sent senators to a closed-door session, but they came to a stand. We understand that over 90% of them were in agreement to that motion. Where do we go from here? State government and local government, they have a deadline by the federal government upon which, if you do not do local government elections, you will not get the funding. But how are they handling this? We'll be right back after this break, everyone. Let's go. Senator Tony Nwoye has been speaking with us over the local government autonomy. Now, where do we go from here? You are saying there are flagrant abuses and breach of the Supreme Court judgment. But again, there are those who think, okay, what can the lawmakers do? Because we now understand that some of your colleagues are saying that there should be precise and decisive move to capture the essence of the Supreme Court judgment in the constitutional review process that is ongoing. How concrete would that be?
The constitutional review about local government autonomy is a different matter altogether, not about the issue of financial autonomy. What the senators or House of Rep members are proposing in the review process that is ongoing is on the issue of, for instance, on the issue of federal INEC conducting a local government election, and not on the issue of that particular provision.
The finances.
Yes, finances. It's very clear.
The control of their monies.
Yes, it's very clear. Remember that the 36 state governors, through their lawyers and through their attorney generals, were defendants in the suit. They filed the argument to defend the suit, because they were the ones that were sued by the Attorney General of Federation. And the Supreme Court, check page 32, 33 of that judgment, where the Supreme Court said expressly that there was never, or the House of Assembly should never make any law no House of Assembly should make a law to interfere with that, how that money should be managed or disbursed. And also, page 28 of that judgment says, I mean the lead judgment by Justice Agim, that the Constitution never envisaged joint ownership. You even mentioned it.
Yeah.
And he did not stop at that. He went to interpret that section 162, subsection 6. They are using the State Assembly to rely to create law to violate Supreme Court judgment. The Supreme Court said, Justice Agim said no.
On that page 32 that you referenced,
yes,
the Supreme Court, the Honorable Justice decided that the state's retention and use of local government council money received on their behalf for their benefit does not fit into the tenor and scheme of the provisions of Section 162 of the 1999 Constitution that requires subsection 6 and 7 and 8 that all money belonging to and due to the local government councils from the federation account be distributed to the local government councils in the state. No law of the House of Assembly or state can validly interfere or deal in any manner with money distributed to the local government council from the federation account. So the state House of Assembly or the state cannot make law on the funding of the local government.
But they are already making.
The example that you gave.
Just my state yesterday just signed it. The governor will sign it into any time from now. It was executively sent. They're already making. So I don't want to be personal about Anambra State. They're already making. And you see, just like I said, these are the learned justice of Supreme Court. They know that that is what they are going to do. They said in their judgment that this practice has been on for the past 20 decades. That the intention of that joint account, state and local government joint account, was after 1999 era. That it was cumbersome, and in terms of logistics, it was huge for the state local government to come to Abuja, so and so local government to come to Abuja to collect their check vis-a-vis their allocation.
That's why that pot was created.
That was why the pot was created. Justice Agim said it. Justice Agim said it very clear. He said that was the error. He said now, 1999, they now decided, or the framers of control now decided that the best thing is that let there be a joint account where this money will come and will be disbursed to state. I now went further to say the state governors, through the House of Assembly, through the names they call the joint account, now stifles this money and now using it as their private personal something. Say no, it is not meant to be. That's why he now gave an order in page 54. Relief 9 and Relief 12, page 55. Justice Agim gave that order, stopping them from interfering. Let me read for you, Chiu. They say using any name at all.
Yeah, it said 54.
Yes.
The eighth relief says,
yes,
a declaration that any of the elected or other officials of the 36 states of Nigeria who through the instrumentality of either a state law or an administrative directive or order dissolves or causes the dissolution of any of the democratically elected local government councils or its state has gravely breached the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended. Hence, by that token, has committed a gross misconduct. It went further to say a declaration that by the virtue of Section 162, subsection 3 and 5 of the Constitution of the Federal Republic of Nigeria 1999, the amount standing to the credit of local government councils in the Federation account shall be distributed to them and be paid directly to them.
Children 10, 11, and 12.
It says a declaration that a state, either by itself or its governor or other agencies, has no
governor or other agencies,
has no power to keep, control, or manage or disburse in any manner allocations from the federal account or to the local government councils. Went further to say a declaration that the current practice of state keeping, controlling, managing, and disbursing local government allocations from federal accounts is unconstitutional and illegal. A declaration that a local government council is entitled to a direct payment from the federation account of the amount standing to its credit in the said federation account. An order of injunction restraining the defendants, which are the 36 states and the attorney generals, by themselves, their previous agents, officials, or however called from further collecting, receiving, spending, or tampering with local government council funds from the federation account for the benefit of local government councils.
An order And further on, if you read, an order that the Federation or federal government of Nanda, through its relevant official afterwards, commence the direct payment to each local government of the amount standing to create each of them the Federation account. What I'm saying, Shehu, is that they now created, or they are creating, agents, using the agencies, using any name they call it, now to subvert, to violate these threat Supreme Court decisions. And these Supreme Court justices knew that this is what they're going to do.
But it's easily, I mean, the Relief 12 here,
yes,
it's easy for those who are aggrieved to go back to the Supreme Court.
They don't need to get to court.
No, because if there are breaches, because there is an injunction to say you cannot, collect or receive or spend or tamper with the local government council funds. If such is happening,
I don't think
you can go to court for...
No need of Supreme Court. Are you telling me, Shehu, that I'm not a lawyer, I'm a medical doctor by training, but remember my twin brother is a lawyer. Are you saying that Supreme Court has given a judgment to say Shehu is a local government chairman? Don't use any name. Say governor, don't use any name.
But if they are doing it, Senator...
If they are doing it, the security agencies, we have Attorney General of Federation, we have the agencies of federal government. This money belongs to federal government. You have ICPC, we have NFIU, we have EFCC. There should be, through the Office of Attorney General, ensure that judgment of Supreme Court is enforced.
Obeyed.
Yes, because the money comes from federal account, federal account. The IGR from the state, from local government, let them manage what they want, the state government or the House of Assembly want, let them do. But this money that comes from federal government, whose Supreme Court has given judgment direct, the best thing, we are calling on Attorney General of Federation. We are calling on all the relevant security agencies, that NFIU, ICPC, and the EFCC, to ensure that judgment of Supreme Court is obeyed. Remember that the day we screened the Chief Justice of Nigeria, Justice Kudirat Kekereku, that she said, when we were asking her questions, that she should, one of her cardinal policies to ensure that there's a enforcement of judgment of Supreme Court, of courts. She didn't say Supreme Court, judgment of courts. Now, the highest court of the land has given a judgment, and they visage that this is what the people are going to do. And now, when some of them are saying, few of this governor want go to court. Go to court. Any council chairman who releases his or her money to any state government apparatus in the name of joint account and everything is answerable to EFCC, because those council chairmen, they don't have immunity. They have councillors. Councillors should be the one.
But what about the breaches caused by the state assembly and the governors and the state government?
The breaches they are causing, the money is not going to them direct. Let me give you that, for instance. In my own state, the new law they have passed is saying once they receive the money within 2 days, they should pay it into a joint account within 2 days. So who receives the money? The local government chairman, for instance, who receives the money, who knows that there's Supreme Court judgment. That is the essence of our motion. He knows that there's Supreme Court judgment already. I know that Supreme Court has said, you, House of Assembly, don't do any law, don't use any agency to circumvent this judgment, to touch this money. So if a local government chairman carries or takes his or her money to go and give to agency of state government, that person is answerable to the relevant agencies. I remember, let me tell you, these councillors, these council chairmen, we are appointed by them, either by election or whatever. Let us even call it by election or by selection. All will know that they have been elected, in quotes. So why wouldn't they trust them with this money? They don't have immunity, Cheun.
Senator, thank you so much indeed. Senator Tony Nwoye, representing Anambra State in the Senate. Thank you so much indeed for the time tonight. I appreciate your advocacy on this.
Thank you.
Thank you. That's our show for tonight, everyone. Many thanks for watching. I'm Sean Kimaloye. God bless Nigeria.